Hello to all of our virtual attendees and welcome to our beneficiary workshop. If you have chosen to attend today, it's probably because you are either named as a trustee or a beneficiary in somebody's estate planning documents, or maybe you're just curious about what rights a beneficiary has or what the trust administration or probate process looks like. So today we're going to be going through the different steps that are involved in both of those processes, and you will have an opportunity to ask any questions that you have as I go through this information. And if you would use the question and answer feature on Zoom rather than using the chat, that will allow me to see your questions as they come through, and they will come through anonymously. So that is the preferred method. All right, so the first thing I wanted to go over is just some of the first steps that you should take when a loved one has passed away. The very first thing that you or the trustee is responsible for doing is notifying the rest of the family members. The second step would be to secure the property of the decedent. So that includes getting access to their home if they were still living at home, and getting an idea of what sorts of assets that they have at the time of their death. That typically would include different accounts such as bank accounts. That could include investment accounts, IRAs. It can include tangible property like vehicles and that sort of thing. So you want to start getting a grip on those things. If you are not a named trustee or executor in your loved one's estate planning, you may want to just allow whomever is named as that person act and step into that role and just let them know that you're there to help. The next step would be looking for any legal documents that your loved one might have. This would include wills, trusts, any other documentation where they might have written down who they want to receive certain items, who they want to be responsible for getting their affairs in order. The next step would be to make funeral arrangements. And after that, after the funeral, after a death certificate has been issued, that is usually a good time to give us a call to find out what your next steps will be. Before setting up an appointment with our trust administration and probate department, we want to make sure that you have a death certificate in hand, and ideally that you have located the estate planning documents associated with your loved one's estate. So that, again, is typically a will or a trust. So once those items have been located, you may be wondering what sort of role you play in this process. So you might be a beneficiary of somebody's estate or their trust. A beneficiary is a person or an entity who is entitled to receive money or other benefits upon the death of a benefactor. So you may be a beneficiary of a specific bequest in a trust or a will, which means that there is a section in the estate planning document that outlines a specific item or a specific amount of money or even a specific piece of real property that you're entitled to receive. You might be identified as a residuary beneficiary, which means that after all the specific bequests have been satisfied, you are entitled to a portion of the remaining assets in the estate. Or you may be a contingent beneficiary, and that would mean that you are only a beneficiary under certain circumstances. For instance, if one of the named beneficiaries had passed away before your loved one and are no longer entitled to a share, then perhaps you would be a contingent beneficiary. If your loved one passed away and had a trust, you might be wondering exactly what a trust is. Well, a trust is a legal document that acts as an agreement in which one party holds and manages property for the benefit of another party in order to avoid probate and to protect assets for the future. And avoiding probate essentially means that your property would pass outside of the probate court and directly to any beneficiaries that you name in your trust. The trustee is the person who is named in the trust document itself, who is responsible for handling all of the assets held by the trust, and they're responsible for following the terms of the trust. So when a person establishes a trust, they will pick a person who they want to handle all of their affairs for them. Typically, they'll also name a lineup of additional individuals after that first person, just in case the first person named is unable or unwilling to act. But the first person in that lineup is always the first and only person that an attorney can speak with after somebody has passed away. So again, that timeline for trust administration begins after your loved one has passed, and Michigan law mandates that all beneficiaries must be kept reasonably informed throughout the trust administration process. Typically, what this means is the trustee is responsible for, number one, notifying all of the beneficiaries that they are a beneficiary and that their loved one has passed away. And to give you an idea of about how long the process will take before distributions are made to each beneficiary out of the trust. You are entitled to the trust provisions that pertain to you. So what that means is, as a beneficiary, you are not necessarily entitled to receive the entirety of a trust or a will, but what you are legally entitled to is copies of the exact sections in the trust or the will that outline what you will be receiving. The trustee has a duty to make every effort to locate all beneficiaries. So if there's ever an instance where somebody has passed away and we are examining their trust and we are trying to identify beneficiaries, particularly in a case where perhaps somebody has dictated that they want all of their assets to go to their grandchildren, but they don't identify their grandchildren by name. The trustee has a responsibility to do their due diligence to track down every living grandchild of the person who passed, even if they aren't specifically named in that person's estate planning. The next step in the trust administration process is for the trustee to publish what's called a notice to creditors. And this is a notice that gets published in the local newspaper. And creditors have 4 months after the date of this publication within which to file a claim against the estate or the trust. After that 4-month period has passed, all additional claims are barred. For that reason, we advise all of our trustees to not make any distributions to beneficiaries, at least until that 4-month period has ended, just in case any creditors come out of the woodwork and their claims need to be satisfied. Creditors who make claims are not guaranteed payment, and this is especially true in cases where people have successfully funded all of their assets into a trust, which provides creditor protection. Creditors cannot go after those assets. Sometimes, if not everything made it into a trust and some assets have to go through probate, some of those assets may be on the table for creditors, but an attorney can help you work through those. The next step in the trust administration process is preparing what's called an inventory. And what the trustee does during this step is they make a list of all of the different assets that are in the trust at the time of your loved one's passing. So again, this includes any real property. This includes bank accounts. This includes investment accounts, stocks, bonds, anything you can think of, anything that has a title and can be put into a trust. We're making a list of those items, and we're also determining what the value of each of those items was as of the date of your loved one's passing. One of the reasons we put together this inventory is so that we can use it when we prepare a trust accounting. So the inventory can also be considered the starting value of what was in the trust. Once we have prepared an inventory, we assist the trustee in liquidating each of these assets. Typically, what this looks like is cashing out all accounts and consolidating everything into a new account that is in the name of the trust, which runs under a separate tax ID number for the trust. So asset liquidation typically takes anywhere from 4 to 9 months. Jumped ahead a little bit here. Part of the reason it can be a timely process is it takes a little bit of back and forth with a lot of companies, completing claim forms, submitting them, waiting for them to be processed. Also, when it comes to real estate, a lot of times it can take time to get a house ready to be listed on the market. A lot of cleaning is involved, going through your loved one's property with the rest of your family, and that can take just a little while to get a house listed. Once real property is sold, the same thing goes for those funds. They get consolidated into a trust bank account. Once all of the assets in a trust have been liquidated, we move into the accounting phase of trust administration. An accounting is prepared after all of those assets have been liquidated. And what we do on our end and what a trustee is responsible for is putting together a spreadsheet or a document that shows everything that has gone into the trust and everything that goes out of the trust after an inventory has been established. And this is something that every beneficiary is entitled to. So once everything in a trust has been liquidated, before distributions are made to each beneficiary, every beneficiary has the opportunity to review the accounting for the trust. That way you can see everything that was in the trust when your loved one died and everything that is in the trust after the trust has been administered. Some examples of income on an inventory, of course, would be everything that's been liquidated. So that would include life insurance policies that have been cashed out, IRAs that have been cashed out or rolled over, bank accounts that have been cashed out, consolidated. Expenses are typically going to be anything that relates to the upkeep of real property. So that's typically going to be utilities, keeping the lights on, keeping the insurance paid, any funeral expenses. Once the accounting has been finalized, the trustee can move forward with making distributions to the beneficiaries. So the trust itself runs under a separate tax ID number. So this no longer runs under the Social Security number for the grantor. All right, so this is referring to what we call a separate share trust. So this is specific to only the trusts that we create at our firm. Each of our trusts have the option for beneficiaries to receive their inheritance in a separate share trust. And this allows the beneficiary to protect their inheritance from any creditors that they might have. And it's also a good option for any beneficiaries who may be receiving income-based government benefits that could potentially be impacted by receiving a lump sum inheritance. So if you were interested in a separate share trust, what that looks like is appointing somebody to be a co-trustee along with yourself. Both of you have access to those funds, but you as the beneficiary are the only person who's entitled to use those funds. That separate share trust also runs under its own separate tax ID number, and you can only hold your inheritance in this separate share trust. You cannot commingle funds from any other sources. Your other option for receiving your inheritance would be outright and free from a trust, and that would look like the trustee simply writing you a check made out to you in your name and handing that to you at the end of the trust administration process. All right, so another option for your distribution is the supplemental needs trust. And this option is particularly for beneficiaries who are either unable or unwilling to manage their own money. This might be somebody who is disabled or somebody who has poor money management skills, somebody who has substance abuse problems. In those sorts of instances, a trustee can dictate that their inheritance goes into a supplemental needs trust. And the way that that supplemental needs trust works is the trustee is in charge of managing that money for the beneficiary and paying for certain items on their behalf. The rules for a supplemental needs trust are that monies can be used to pay for the beneficiary's health and security. So oftentimes what a trustee will do is set up automatic payments to make sure that the beneficiary's bills are paid and that they have the ability to cover their health care and just daily living expenses. This supplemental needs trust is not controlled by the beneficiary, and the beneficiary cannot access it. It is controlled by the trustee. The benefits of this are very similar to the benefits of the separate share trust. It has automatic creditor protection. So if you're somebody who has a lot of potential creditors, they can't access this money. It also is great for if you are receiving any sort of income-based government benefits or disability. Your benefits will not be impacted by your inheritance. Final distributions cannot be made until the notice to creditors expires. So that's 4 months after publication. Administering a trust typically takes anywhere from 6 to 9 months, and this has a lot to do with how many assets are in the trust at the time of your loved one's passing. And at the end of trust administration, one thing that our office does is we send each beneficiary a document called an agreement and release, and we send each beneficiary a copy of the trust accounting. So that way everybody has the opportunity to look at what the starting value in the trust was, see everything that went into the trust, everything that came out of the trust. You'll be able to review the amount that you're receiving. And by signing off on that, you are agreeing to that amount, and you're also releasing the trustee from any liability. All right, so I'm just going to take a peek and see if we have any questions come through. Responsible for father's trust in North Carolina. If you live in North Carolina and your father's trust was established in North Carolina, you should check with a North Carolina attorney. If you call into Carrier, we may be able to refer you to like a partner attorney or somebody that we work with. But otherwise, we are not licensed to practice in North Carolina, so we would recommend meeting with a local attorney. Is it routine for a beneficiary to indemnify or hold harmless a personal representative at the time of the approved final distribution? Yes, that is routine. So that is part of what's built into those agreement and release documents. And that's why we provide each beneficiary with a full accounting so that if they have any questions about the way that the trust was administered or have any doubts about the trustee's actions, they have the ability to either agree or decline to agree. If we get to the point in the process where we are making final distributions and any beneficiary will not sign off on their distribution, what we typically do is we escalate it to be approved by a judge. So at that point, a judge would have to review everything that the trustee did and make a decision as to whether or not the trust accounting and final distribution amounts are approved. And we highly recommend that trustees do not move forward with making distributions to beneficiaries until that accounting has been approved, either by the beneficiaries unanimously or by a judge. All right, so those are our only questions for now on the trust administration side of things. So what if there is not a trust? If there is not a trust, the first thing we want to take a look at is whether or not the person who has passed away had any sort of will in place. So a will is a legal document that acts like an instruction manual to the court, and it outlines a person's wishes for after they pass away. So oftentimes a will outline where a person would like their assets to go. And it also states who they would want to care for any minor children in the event that they have any at the time of their passing. If somebody does not have a will, then the court has a predetermined list for how assets are distributed and who handles the estate. So in the state of Michigan in particular, it goes in a certain order as to who's entitled to receive assets when somebody has passed. So if somebody passes away, the first person entitled to their belongings is their surviving spouse. If they do not have a surviving spouse, then the kids are next in line, and so on and so forth. So it just has to follow the order that the state of Michigan provides. A personal representative, this term is often used interchangeably with the term executor, and this is the person who handles the administration process with the probate court. So in a will, there will be a section that indicates who the decedent wanted to name to be the executor for their estate. That is the personal representative. So the timeline for the probate process is similar in some ways to trust administration, but does vary in others. The first step in probate is to submit an application to the court to open a probate case. And in almost every instance, this is going to be considered an informal probate. Every beneficiary will receive a full copy of the application and the testimony to identify heirs in the mail. If you happen to be a beneficiary of an estate that's being probated, you will receive a lot of documents in the mail, but 99% of the time, you don't need to do anything with those. They're just notifying you of every step of the process. There are notices that are issued to the probate court. So you will know an estate has officially been opened when you receive a notice of appointment from the probate court. And that notice of appointment is a document that notifies you that an individual has been appointed as a personal representative. And you'll also be notified of any attorney fees that that personal representative has paid. Again, when you receive these sorts of documents in the mail, you don't need to do anything. This is just to keep you notified throughout the process, and you can keep these documents for your records if you so choose. The notice to creditors is also published in the event of probate, and the same rules apply. Once published in a local newspaper, creditors have 4 months after that date of publication to file a claim against the estate. After 4 months, any claims that come through are automatically barred. Creditors who make claims are not guaranteed payment. In the instance of probate, there are occasionally times when a claim will need to be paid out of the estate funds. So that differs slightly from trust. When you have a trust, your assets are a bit better protected than when you don't. So in the event of probate, oftentimes there are some claims that may need to be paid, but that's something that an attorney can determine for you. The friend of the court is also notified when a person has passed away and they did not have a trust. Whenever any assets are being probated, this is just an automatic step in the process that is required. So what happens is a notice goes to the friend of the court to let them know that a person has passed away. And at that time, it is on the friend of the court to determine whether either the decedent or any of their heirs owes any child support or any outstanding fees that need to be paid either out of the estate or out of that heir's inheritance. The names of all of the beneficiaries are provided to the friend of the court for this purpose. And if they do owe any money, their distribution could be garnished by the friend of the court. Just like we do in trust administration, we put together an inventory for the estate. And again, this just lists all of the property that is subject to the estate and their value as of the decedent's date of passing. We file this inventory with the court, and that must be filed within 91 days after appointing a personal representative. The court fee is determined by the value of the probate assets. So there is a calculation that they use to determine the fee, which is a percentage of the total value. And if you're ever curious, you can always take a look at what's on the inventory, and most counties will have a calculator for court fees on their website. An inventory only includes assets that were in the individual's name alone. So if there were any accounts that were joint, those do not go through probate. Those would automatically go to the remaining individual named on the account. Next step in the probate process is liquidating those assets. So once a personal representative has been appointed, they have the authority to start liquidating assets. They are able to apply for a tax ID number for the estate. And with that, they will open a new estate bank account. And then as they liquidate assets, they will deposit the funds from those assets into this new estate account. Just as we do with a trust, we prepare an accounting for the estate. So we use the value of the inventory as our starting value, and we show everything that goes into the estate account and everything that comes out of the estate account. Examples of some income for an estate could be interest on bank accounts, capital gains and investment accounts, any refund checks that a decedent may receive, life insurance payouts, balances from any checking or savings accounts that were in their name. And again, expenses are going to be any utilities that had to be paid, particularly if any real estate was not in a trust and needed to be probated, any funeral expenses that need to be paid, and any insurance that needed to be paid. Final distribution from an estate cannot be made until the notice to creditors expires. This is not optional when it comes to probate. This is required by the court. And again, our office sends beneficiaries that agreement and release document. This is the document that they're able to review along with that accounting for the estate to determine everything that came into the estate, out of the estate, and they can sign that, agreeing to the amount that they're receiving and releasing the personal representative from liability. When an estate has been fully distributed and all of the beneficiaries have received their share, you'll receive a final document in the mail that's called a sworn statement to close. And again, this is just for your records. The court won't officially close an estate for 28 days after they receive the sworn statement to close. And that is so that any beneficiaries who want to go to court and argue against any part of that accounting or agreement and release, they have 28 days from the time they receive that sworn statement to do so. And probate must be open for a minimum of 6 months. So even if a personal representative is really on top of their game, gets everything liquidated, everything is consolidated in an estate account, they still are required to wait that 6-month period before making distributions. If an estate is open for over a year, each beneficiary will receive what's called a notice of continued administration, and that will notify you of the current status of the estate. I'm going to take a look and see if we had any additional questions. All right, so it looks like we have somebody with a trust that was set up in Arizona, but has assets in Michigan. Typically, there's not an issue between states. You're still going to follow the same process for liquidating those assets. As you liquidate, the companies will send checks to the trustee, and the trustee is just responsible for depositing those checks into a trust bank account. And do inherited IRAs, 401ks, Roths, or life insurance with named beneficiaries have to wait 4 months to receive their bequests? Not necessarily. Any assets that name direct beneficiaries can be paid out directly to those beneficiaries. And those sorts of assets are off the table automatically for creditors because they do name a direct beneficiary. So The assets that you want to worry about waiting to distribute are going to be the ones that don't name a direct beneficiary and are not in a trust. So the assets that are really on the table for creditors are anything that needed to go through probate or anything that needed to be claimed using a small estate affidavit if it wasn't enough to go through probate. And that's one other thing to mention that actually isn't in this slideshow. There could be circumstances where there are assets that were not in trust, did not name a direct beneficiary, but do not meet the threshold to require going to probate court. And so in Michigan, currently, the threshold is a total value of $24,000. So an example of that would be if your loved one passed away and they had a checking account that didn't make it into a trust and didn't name a pay on death designation, but that account had under $24,000 in it. Their next of kin could use what's called an affidavit of decedent successor. That's what it's called in Michigan anyway. It's also called a small estate affidavit to be able to claim and get access to that account. So that is an exception to some of these rules if there are several assets that fall under that threshold. Looks like I had one more question come through. If you have a trust, do you need to go through probate court? No, as long as all of your assets either are in a trust or name a direct beneficiary, then your loved ones would avoid going through probate court. The only time you need to go through probate court is if you pass away and you have assets that were, like I said, either not funded into a trust or don't name a direct beneficiary. If your home property is currently in trust, but down the road you need Medicaid, should you change the title of your deed? So when it comes to questions that are specific to Medicaid planning, I would recommend speaking with an attorney, but I can also recommend, we actually have a Medicaid workshop coming up this coming Monday at 1 p.m. And that would be probably a better time for that question. Because it completely depends on your situation. And unfortunately, without additional information, I wouldn't be able to give you advice on that. I will wait and see if any other questions come through. Last call for questions. All right, I think that might be it for today. So thank you everybody who joined us. Oh, we got one more, one moment. Can a trust be dissolved before the death of the person who formed the trust? Yes. So when it comes to a trust, it's not necessarily that a trust becomes dissolved. It's more so the act of taking all of the assets out of the trust that were funded into the trust. So a trust can exist, but it's not really doing anything if there are no assets in it. So for example, if you set up a trust and you title your home into this trust and an investment account, once you retitle your home to transfer it out of your trust and you change the ownership of your investment account to take the trust off of it, then the trust is no longer in existence in theory. The documents still exist, but nothing is funded into the trust. So yes, trusts can essentially be dissolved at any time.